Good morning, everyone. Thank you for joining us today for the Bridging the Gaps in Credit Access with the Movable Property Security Rights Framework webinar. My name is Yuri Alpuche, and I will be your moderator this morning. We are thrilled to have over 320 participants registered for this webinar. This highlights the importance of this topic for many in Belize and beyond. On November 25th, 2024, the Secure Transaction and Collateral Registry was launched, supported by the Movable Property Security Rights Legal Framework, which together create opportunities for businesses and individuals to use their movable collateral, new or used, to access finance. Today, we will be hearing from the team of legal experts on the elements of the legal framework, what it entails, what it does not entail, how it creates legal certainty for lenders and creditors, and opportunities for borrowers in accessing credit. This regime seeks to bridge the gap in access to credit, and as of today, the registry can proudly report that they have over 186 security rights registered in the registry. This is a huge accomplishment for Belize. We will also be hearing from the Deputy Registrar of the Belize Companies and Corporate Affairs Registry on how the Collateral Registry functions, who are the users of the registry, and what are the services and products available to you. There will be a question and answer segment where the audience, all of you, will get the opportunity to ask questions to a specific speaker. Before I introduce our expert presenters, I would like to review the webinar guidelines so that you have the best experience. On the right-hand side of your screen, you should see 3 tabs. One being the poll tab, the second being the questions tab, and the third being the chat tab. Throughout the webinar, the various speakers will be publishing various polls for you, the audience, to answer and to interact, to see and to gauge if indeed you are understanding the contents of the topic or if there is further explanation that's needed on a specific area. Your second tab is your question tab, and this is very important. This is where you, the audience, will be placing your questions. There is also the possibility to vote on a question. So if someone places a question and you also want an answer to that question, then you can vote on it. And the questions with the most votes will trend at the top, and that will then give us more visibility, and more than likely we will be addressing those in that order. And the third tab is your chat tab, and this is for general comments only. No questions are to be placed in this tab. We will not be addressing any questions that is placed in this tab. You must place your questions in the question tab. Also, to let you know that we will be compiling all the questions. So in the event that we do not have sufficient time to address all your questions, we will be compiling them and uploading them on the registry website. And you will receive a link to where this will be. Lastly, all the recording of this webinar, copies of the presentation, and of course the FAQs will be published on the FSC website, on the YouTube channel, and you will also be able to see some of this on the registry BCCR's website as well. It is now an honor to introduce the team of legal experts that will be presenting on the first segment of this webinar, which will look at the movable property and security rights legal framework. Our first presenter is Nicole Garraway, who is a seasoned professional in international trade law and economics with over 12 years of expertise in trade facilitation, economic analysis, regulatory review, and economic integration. Her work spans key areas such as digital transformation, trade, e-commerce, and e-government. Nicole has contributed her skills across multiple jurisdictions, including the OECS protocol member states, Trinidad and Tobago, Belize, and Ghana. Our second presenter, Tira Green, is an attorney at law and digital governance policy consultant with over 25 years of international experience. She has worked with governments, public sector organizations, and private sector stakeholders on policy development, strategy design, and legal and regulatory frameworks. Specializing in state assessments, strategic planning, and gap analysis, Ms. Green has led reforms in trade, data protection, electronic transaction, government digitization, and ICT initiatives across the Caribbean and other developing states. Her work spans jurisdictions such as the OECS Protocol member states, Trinidad and Tobago, Belize, St. Lucia, Antigua and Barbuda, and Smart Africa member states. Ms. Green and her team have been instrumental in modernizing Belize's legal frameworks, contributing to groundbreaking legislation such as the one we will discuss this morning. And our third presenter, Alexander Gafour, brings over 10 years of experience in law, finance, and innovative ventures. Alexander specializes in international corporate structuring, tax optimization, and intellectual property in emerging markets. As Director of Regulatory Compliance for the FinTech Association of Trinidad and Tobago, he plays a key role in shaping regulations for digital payments, cryptocurrencies, and FTFs in the Caribbean. He has also contributed to the Trinidad and Tobago's e-readiness assessment and e-commerce strategy. Combining legal expertise with business acumen, Mr. Gafour remains at the forefront of digital finance, leveraging blockchain technology and strategic innovation to drive regulatory and business solutions. I welcome the three of you this morning, and I now hand over the floor to you, Nicole.
Thank you so very much, Yuri, and good morning to you, and of course to all our attendees we have here with us. We are very happy to have you at this morning's session, and we do hope that it will be an informative and interactive session here today. As indicated in the introduction, we will be focusing this presentation on the movable property security rights legal framework. Just to quickly give you an overview of the presentation, first we will present the objectives of the Act. Then we'll go straight into the legal and procedural considerations and innovations of the Act. We will then discuss key benefits and contextualize these within the context of the scope and application of the Act. We will note some exemptions and exclusions, and then speak to some key terms as it relates to the interpretation and application of this new legal framework. Additionally, noting that this Act establishes the collateral registry system, we will discuss the system in terms of its intended use and some key institutional arrangements thereunder. And we will also discuss principles, precepts, and provisions as it relates to the creation, perfection, and enforcement of security interests. And in so doing, we will delve into some of the key provisions of the Act. And then we will also note some of the summary of priority rules. We will discuss a summary of priority rules. And then we will note some post-default procedures as established under the Act in terms of what you can do or what right you possess after default has occurred. So this, of course, would be very important. Obviously, we hope that such situations would not arise, but what we are highlighting there is the fact that the legal framework provides for or outlines processes which would guide such an occurrence should it happen. So I'll delve straight into this. And also just to note, of course, as indicated by Yuri, that during the session, we will have some poll questions just to ensure that you're staying with us throughout the entire session this morning. So in terms of the objectives of the Movable Property Security Rights Act, it seeks to establish the required institutional arrangements, such as the Office of the Registrar and a Registry, that is the Collateral Systems Registry, to facilitate the registration of security rights in movable assets. It further promotes consistency and certainty throughout the framework as it relates to secured financing, relating to movable assets. It enhances the ability of individuals and business entities to access credit using movable assets, because of course we know that for micro and small enterprises, it is often quite difficult to meet the capital requirements, the typical capital requirements that may be needed by a financial institution, but instead being able to leverage movable assets, that is something that is more accessible to small and micro enterprises. So this act, of course, provides the legal framework through which this can be done. And of course, in so doing, it addresses the challenges confronting entrepreneurs and businesses so that they can access credit, access finance by leveraging these movable assets as collateral in an effort to innovate and ensure longevity and sustainability. This is very important because for those of us who often track what's going on in terms of international development, and we read what the development associations and organizations such as the World Bank often say in terms of their assessments as it relates to doing business, as it relates to entrepreneurship and so forth. One of the main challenges that has been cited for years relates to the inability of micro and small businesses to access finance. And the introduction of this act, the Movable Property Security Rights Act, by the government of Belize really seeks to ensure that there is a legal framework which gives backing and foundation to the leveraging of movable assets, thus allowing micro and small enterprises to be able to access greater finance and to be able to grow their businesses and by extension, grow the economy of Belize. As it relates to some legal and procedural considerations and innovations of this act, it's important to note that the act provides clarity of processes and procedures. When we say this, what we mean is that it determines clear processes and requirements as it relates to the registration of an initial notice, the registration of amendment notices, the registration of cancellation notices. And it further describes who may register these notices and how. This is very important because these notices affect elements and processes and priority in terms of enforcement and perfection. So that creation, enforcement, and perfection. So that is very important. Additionally, as it relates to the clarity of processes, there are also a series of terms that are identified and defined in the interpretation section. This is very important as well because it guides us in terms of how we are to apply and interpret certain terms. It is quite a modern legal framework, and it also entails and features streamlined procedures. The Act considers rather the current era in which we operate and gives credence to principles of e-government because, as you may know, for the persons who have already perused the Act speaks to an electronic system. The collateral system, registry system is in fact an electronic system. And similar to many of the other initiatives being undertaken by the government of Belize, very many things now are being done under a digital transformation agenda. So we have considered that within this framework, and it is thus reflected. So concepts of digital transformation, concepts of e-government, concepts of e-transactions are in fact reflected in the Act. So that is something that you would see featured there as well. Some other legal and procedural considerations. The Act aligns with international standards, particularly the UNCITRAL Model Law on Secure Transaction, and further builds on the best practices of other jurisdictions, because there have been some other jurisdictions further afield outside the Caribbean that have undertaken and implemented a similar regime. Additionally, the Act also features flexibility for growth. And in that, we have ensured that regulations can be made for the adaptation given any developments, any new forms of movable property that may emerge, or any recognitions that there are certain things which need to be amended or further guidelines or processes that are required to really ensure the effective implementation of the Act and the achievement of the registry as intended. As it relates to benefits to be derived from the Act, now just based on what we've discussed thus far, we see that core to this framework is really being able to encourage greater business activity to create a better enabling environment for business in Belize, with particular focus on the smaller enterprises. So this act undoubtedly improves access to credit. It creates legal certainty and risk reduction because there is protection afforded to secured creditors by establishing enforceable security agreements. And in fact, this is a term that you would see firstly defined in the act, and then of course used thereafter, because it's very important. This is what sets the stage really for the honoring and leveraging of security interests. It heightens clarity as it relates to secure transactions, lowering the risk of disputes. It promotes trust in the national collateral regime of Belize, because now we will have a system that persons can refer to ensure that people don't double book, so to speak, as it relates to leveraging a movable asset for collateral. So now there is greater certainty and reduced risk attached to financial institutions, lending or advancing funds to smaller enterprises which have leveraged their movable assets as collateral. So this is very important. I know it will be important for the financial institutions, and even as a small business owner or someone in that sector, it's important to know as well that there is this framework that has now been created through which there is greater transparency, there's greater accountability, there's greater trust, and there's greater certainty. Great. As it relates to some other benefits, of course, we can see how this can promote greater economic growth and innovation, because now we have increased access to finance. So we have businesses that can now invest in areas of product development, invest in areas of innovation, invest in areas of e-commerce. So that, of course, can increase productivity, revenue generation, employment generation. And of course, there are effects that would accrue over time to the wider economy. And we also have a streamlined process which gives consideration to cost effectiveness. The e-registry, that is the electronic collateral registry system, simplifies administrative processes and procedures and improves transparency, accountability, and compliance. So that is also very important, because we want to ensure that whatever we implement will not be burdensome in terms of cost or in terms of administration to small businesses, because as we know, time is money, especially when you have a small business. So we have borne that in mind in crafting this legislative framework, and of course, supported by FSC, and we'll hear from the Deputy Registrar as indicated in the introduction. We'll hear a little bit more about how the system is actually intended to work. So that will bring together these points, of course. We'll now pause for our first poll question, which will appear shortly on your screen.
So, audience, can you kindly provide an answer to the poll question? Okay, thanks for that feedback. So I see someone saying that they're not seeing the question. You should find it under the poll tab on your right. You will see a polls tab. Click there and see if you see the question there. Okay, Nicole, so we have 189 people that answered the question, and 74% of the responses selected C as the answer to the question, 20% selected A, and 6% selected B.
Okay, thank you very much for that, Yuri. So if you're part of the 74% who selected C, then you're absolutely correct. Essentially, this question, the intention of this question rather, is really to emphasize the fact that the Movable Security Rights Act focuses on leveraging movable assets, right? So that is why C is selected as the correct answer. So excellent to the persons who chose C, and to the persons who may have gotten a little bit confused because it was a bit tricky. For A, I included immovable, and for B, I only selected movable. And for the persons who have just voted and have added to C, welcome to the winning side, so to speak. But I'm very happy that most persons thus far have been following and do understand, in terms of the principles behind the Movable Security Rights Act. And to the persons who may have made the error, it can happen, but just again to reiterate the fact that this act, this legal framework, focuses on movable assets, leveraging of movable assets. So with that, I think I'll continue and just touch here on the scope and application as it relates to the Act. The Act covers and focuses on movable assets, and movable assets can take into consideration both tangible and intangible assets. Tangible assets meaning all types of goods, whether motor vehicle, crops, machinery, livestock. Intangible assets refers to things that we can't readily see and touch, as you would know, back in the days of social studies, civics, and so forth. So here we're talking about accounts receivables, for example, deposit accounts, electronic securities, and of course, intellectual property rights. As it relates to the types of transactions covered under the Act covers every transaction that secures payments or performance of an obligation without regard to its form and without regard to the person who owns the collateral. Examples include credit purchase transaction, credit sale agreements, floating and fixed charge. So these are just some of the examples of the types of transactions that can be covered. As it relates to the flexibility aspect of the Act allows for security interests in after acquired property, ensuring that future assets can also secure present obligations. In this way, it accommodates the dynamics of the realities of the business environment of Belize, such as changes in the collateral or the nature of the secured obligation, because we know sometimes this happens. Things change, but if this happens, you have to register an amendment notice. So in this case, an amendment notice can be registered. So it's just, to note that there is flexibility, but there is a procedure as well that has to be followed, right? If we can just quickly touch on some exemptions or exclusions within the scope of the Act does not cover a security right in book entry securities under the Securities Industry Act. It does not cover the creation, lease, or transfer of interest in land, excluding a right to payment that arises in connection with an interest in or a lease of land. It does not cover any right to set off under relevant netting legislation. It does not cover any shareholder loans of a credit union as defined in the Credit Unions Act. It also does not cover, except as otherwise described in the Act, a lien, charge, or other interest created by another law. And it does not cover security rights in proceeds of collateral if the proceeds constitute a type of asset that's governed by another law. And these exemptions have been included because we want to ensure that the regime does not contradict with any other regime that has been established. So it's really to ensure complementarity and to have clear lines as it relates to what would be governed by the Movable Property Security Rights Act and what would be governed otherwise by other legal frameworks that have been previously established. So that's why we have determined that these exemptions or exclusions are relevant and have then been included in the Movable Property Security Rights Act. Now, you may recall I mentioned earlier that there are some key terms which we have identified and defined within the scope of the Act. This is, of course, to ensure there's clear interpretation and application as it relates to the provisions and principles of the Act. We have before you just a series of some of the terms, not all, some of the terms that we use in the Act. Collateral, to refer to a movable asset that is subject to a security right, or receivable, that is the subject of an outright transfer. Movable asset, which we touched on already, to be considered whether it be a tangible or intangible asset. we already described, both in terms of what tangible will cover, what intangible will cover. A grantor, that's very important. It's the person that creates a security right to secure either its own obligation or that of another person. It could be a buyer or other transferee, a transfer and an outright transfer of a receivable, depending on the type of collateral we're referring to. We also define secured creditor. There is also a definition for secured agreement. That is also important. Security rights, notice, whether it be an initial notice, amendment notice, or cancellation notice. And just to, if I can quickly go back here, when we say means of communication in writing, again, just to reiterate, we're in that era of digital transformation. So writing would also include in electronic form, and this aligns with the principles and precepts of the Electronic Transactions Act. So I just want to highlight that there so that there are no misinterpretations as it relates to in writing. It does not necessarily mean pen and paper. All right, and with that, I would now invite my colleague, Ms. Tira Green, to continue as it relates to a key point to note in securities rights and then to move forward. So thank you very much. And Ms. Green, over to you.
Thank you very much, Nicole. Thank you very much, fellow panelists and ladies and gentlemen. So I'll be going into this point and delving a little bit deeper into the law. So the security right under the law in an asset extends to its identifiable proceeds. Excuse me. So therefore, if you have an asset and you think, well, oh, I'm going to sell it or give it away to somebody in return for something else, that then and then get away from your obligations, that's not going to work. The identifiable proceeds will be traced, and if you have sold it to someone and they were not even aware that you owned it, that there was a charge on this, you are still liable, and the money can be taken away from them. So then they will now come back to you for that money. So as the second bullet point says, this means the security interest continues in any identifiable proceeds of collateral, even if the security agreement does not specifically mention proceeds. As a result, the secured party can claim both the proceeds and the original collateral, but it can only satisfy the debt once. So in other words, if you sell it to someone else, the person who is secured, the secured party, can go after you, and they can also go after the money that you have paid the third party. Right. So now we go into the act in terms of the contractual limitations on the creation of a security right. So a security right in a receivable is effective as between the grantor and the secured creditor, and as against the debtor of the receivable, notwithstanding any agreement that may be created limiting the grantor's right to create a security right, entered into between the grantor and the debtor of the receivable or any subsequent secured creditor. So again, we have a rule setting out that sometimes people enter into this, create a security right, and then they try to have a sort of agreement to get out of this, and this agreement would not come into effect. A person who is not a party to the agreement cannot be held liable for any damages resulting from the grantor's breach of the agreement on the sole ground that it had knowledge of the agreement. So if you are completely outside of any agreement and the grantor has breached this, then you have no knowledge of this. You are not responsible. But this is when the grantor breaches it, and not when the debtor. So if the debtor owns the security, as I noted in the slide before, and they have sold it to you, the proceeds of that, the grantor can still go after, the creditor can still go after that. And I'm sure in Belize and in the rest of the Caribbean, we know of cases where that has happened. A security right and a right to payment of funds credited for a deposit account is effective, notwithstanding an agreement between the grantor and the financial institution limiting the grantor's right to create a security right. So we have several notices that can be created and filed under the Act. This we're now going into the procedures. So the initial notice is the notice that's submitted to the registry to achieve the third-party effectiveness of the security right to which the notice relates. So this is basically your initial notice, your application. This I am letting the registry know because the registry is basically the source of truth, source of knowledge and information that we have this security right. Now, anything that has changed, as Nicole had noted before, certain things that can change, you have to file the amendment notice. So this amendment notice would modify any information contained in the related registration notice. This amendment notice could be like change and any change of parties or change of amounts. A cancellation notice is another type of notice that can be filed, and this is a notice to cancel the effectiveness of the registration of all related registered notices. So you can have a cancellation notice in several instances. For one, the debtor has paid off the debt, so everything is now canceled. You may also have a cancellation because the person who has pledged their property is unable, they have said, I'm completely unable to pay this back. Please take the security. And then you have a cancellation because once the creditor is happy, well, okay, I have received the value of the money that I have given, I will be canceling this. Right. So the Act contains specifics on what should be contained in an initial notice. And of course, all this is to be done online. So this includes the identifier and address of the grantor, of the debtor, the secured register creditor or its representative, as well as, of course, a description of the collateral. And the description must be in accordance with the provisions of Section 8 or also in accordance with the serial number if it is a serial numbered collateral. The notice must also contain the period of effectiveness of the registration and, of course, any other information that's required for statistical purposes. The initial notice is to be in English, with the exception of the names and addresses of the grantor and the secured creditor or its representatives. All right. So we come back to the question now of when must amendment notices be registered. So there are two situations: when the registered notice to which it relates contains information that exceeds the scope of the grantor's authorization, or the secured agreement to which the registered notice relates has been revised to delete some collateral. Okay. And cancellation notices, as I had noted, when when the registration of an initial notice was not authorized by the grantor, of course, you'd have a cancellation. When the registration of an initial notice was authorized and withdrawn, but the authorization has been withdrawn and no security agreement has been concluded, so then you have it cancelled. And then where the security right to which the notice relates has been extinguished, and I noted those two scenarios earlier, and the secured creditor has no further commitment to provide value to the grantor. Right? So we now go to poll question 2, which will come up on your screen shortly. So the question is, which of the following does the movable property security rights does not apply to? A security right in book entry securities under the Securities Industry Act. B, security rights in proceeds of collateral if the proceeds constitute a type of asset that is governed by another law. C, A and B above. D, none of the above. So we welcome everyone to go into the poll question and submit their vote.
All right, Tira. So for the question just raised, the majority selected C, A, and D above. 59% of the respondents selected that one, followed by B, followed by D, and then A.
Okay, thank you very much. I hope we didn't trick anyone. Excuse me, because the question was, which one does the Movable Property Security Rights Act not apply to? So as Nicole had spoken on earlier, it does not apply to book entry securities under the Securities Industry Act, and it does not apply to security rights and proceeds of collateral if the proceeds constitute a type of asset that is governed by another law. And the reason why, of course, we have these two is because we cannot have duplicative regimes. So the Securities Industry Act deals with book entry securities. So therefore, that is not something for the Movable Property Registry. And also, if there's another law that is covering and governing the secured interest in an asset, then unless there is something that's carved out and agreed to under this act, we should not be securing interest in that, because we don't want duplicative or conflicting regimes for securities. Because of course, as you know, that can cause a lot of problems, because suppose somebody has one asset that is covered under one act, not the secured this Movable Property Security Rights Act, and they have pledged it there, and then somebody is looking to the security registry and they see that a notice has been registered there. Clearly, they would not know that unless they go and search both registries, they would not be aware that then this thing now has been pledged twice. Okay, thank you. I see no double dipping, got it. Okay, so I will just move on to what the Act establishes, and I fully appreciate that we are trying to not be too legalistic. So even though the slides are legalistic, we are going to proceed, and I think we have been doing it a bit, proceed and not speaking in a legalistic manner. So the Movable Property Security Rights Act, first of all, establishes the electronic registry, which serves as the collateral registry. So we need this. This is just like, say, the registry you have for mortgages, so there must be one central place where these notices are filed and where one can then find as quote unquote the source of truth on the pledges for the movable property. And wonderfully, Belize, of course, is doing this in an electronic system, which makes it much easier for everyone to use and access, and which also makes it much more accessible and cheaper as well. The collateral registry is a centralized system, and it will represent one of the key institutional innovations of the new legal framework. So, and other countries, even in the Caribbean, are also working to establish this. Right now, the Bahamas is there planning to launch theirs as well this year. So we also congratulate Belize in moving in this innovation, and to note that other countries in the Caribbean are moving towards it as well, right? Of course, this promotes greater transparency, efficiency, and compliance. It facilitates the registration online, and you can do amendments and cancellations online as well. So you don't have to be traveling and moving back and forth all over the place. You can do all these things from your laptop. The registry also facilitates informed decision making, as creditors can easily determine when an asset is already encumbered. So therefore, you don't have surprises coming up and then arguments and disputes. And of course, somebody who wants to pledge something gets credibility because they're able to show clear and accurate records of the collateral. Right. So as noted, the electronic registry will receive and maintain notices and make accessible to relevant persons the information. The registrar would have the power to remove the information and archive the information. And this is basically the exact sort of powers for retention, removal, and archiving as contained in most other registries, including various companies' registries, intellectual property registries, and mortgage deed registries. All right. In terms of the creation, perfection, and enforcement of security interests, the security interest is created through a security agreement that clearly identifies the debtor, the creditor, and the collateral. So again, we are trying to avoid any disputes and avoid anybody being cheated, be it the debtor or the creditor, because now we have something that is transparent and that is registered and put on a clearly credible system. Security interests then are perfected through registration in the collateral registry, and clear perfection rules protect creditors against third-party claims that establish priority in the event of default. So if you have created your security agreement and it is now registered in the collateral registry, right? You have that put there clear. As somebody else now comes and says, well, this person had pledged this to me before and I gave them $5,000 or whatever, you are asking, well, can you show me this? So it clearly sets out the priority so that there's no he say, she say like there have been before. Everything has to be properly done, and there is a system for this to be properly done and effective. And for enforcement, the grantors and secured creditors can enforce security interests upon default with remedies established under the law, and the law ensures creditors act in a commercially reasonable manner and balances debtor protections. Prevention abuse, again, before this sort of system and before any sort of law, small, say a micro business owner may have pledged something to a company, even a loan shark, without having any sort of protection. So now the law actually clarifies the procedures of what is owed. You can't have persons taking advantage of, say, the less educated person or a person who does not understand what are their liabilities. Because somebody might come and say, okay, I lent you $2,000 on this. I'm taking this back, but you also owe me another $1,000, because people can be arbitrary and take advantage of persons like that, especially a sole trader or a micro business owner. So this is to protect not only the creditor, but also to protect the debtor from advantageous persons. The law also sets out that the security agreement must be in writing and signed by the grantor. Again, as Nicole noted, you have the Electronic Transactions Act, so that includes an electronic agreement and electronic signature. It must also identify the secured creditor and the grantor and must describe the secured obligation, except in the case of agreement that provides for the outright transfer of a receivable, right? And it must describe the collateral, of course. The security right is created by the security agreement, and the security agreement will provide for the creation of a security right in a future asset. And the security agreement is enforceable and creates a security right irrespective of the satisfaction of the requirement that may be imposed by any other written law. I dealt earlier in the perfection of the security right. So this just specifies the various procedures that is required to perfect the rights. You go and you put in the initial notice, you file the initial notice, and of course you can do the amendments or cancellation notice. A notice is received when it enters into the registry record, so it is accessible to a person who conducts a search of the registry records. Information in a notice enters into the records of the registry in the order in which each notice is received. So this is also important in terms of suppose somebody has gone and pledged their collateral to more than one person, right? The first person who registers it has that first notice. A second person who goes to register it must be able to know whether that person has pledged that registry before, collateral before. So this is also setting out procedures and steps. An electric timestamp will be generated for notice received, so that way you'll know who has filed first. And the registration of initial notice is effective for the period that the secured transactions remain outstanding. And I will now move on to hand over to Alex to discuss from enforcement of security rights.
Hello, good afternoon, esteemed colleagues and all of my friends out here who have come out to learn a bit more about the Movable Property Security Rights Act. So, if a debtor fails to pay or otherwise perform a secured obligation, the grantor and the secured creditor may exercise any right under the Act provided in the security agreement or provided under any other written law. If the security right is being created under a hire purchase agreement, the secured creditor may enforce its rights only in accordance with the Hire Purchase Act. And this is because we previously spoke about the limiting rights of existing legislation on movable property and how that may be used in this context. A secured creditor may exercise its post-default rights by application to a court or in accordance with this part without applying to the court.
I think we go to the poll question now.
Yes.
Poll question 3. Okay, so which of the following best describes the creation of a security right under the Movable Property Security Rights Act? A security interest is created through a security agreement that clearly describes the debtor, creditor, and collateral. B, a security interest is created through an interest agreement that clearly identifies the interest rate associated with the repayment of a loan. C, a security interest is created through a non-disclosure agreement that clearly identifies the terms of the agreement and the collateral. So we'll wait for everyone to submit their vote on how the security right under the Act is created. I think this one is a less tricky one than the other first.
Right, so we have 167 votes and still counting that have responded to the question, and 99% of those respondents selected A, 3% selected C, and 1% selected B. So A is the answer that the majority have indicated to be the right answer.
Okay, great. Well, if you selected A, then you selected the correct answer. So it shows that so far you've been absorbing the material. Ready for the next slide, thanks.
I think that's one before.
Yeah, one before. Right.
Okay.
If there is a default with respect to any obligation, the secured creditor shall serve on the grantor a notification in writing agreed between the parties to pay money owing or perform and observe the agreement as the case may be. This notification must advise of the nature and extent of the default, if the default consists of non-payment and the actual amount outstanding, and also the time by the end of which payment must be completed. So unlike unless the notification is sent out in the prescribed fashion, the secured creditor will be unable to pursue recourse. And we'll be going into some ways that recourse can be gleaned in a bit. So additionally, the notice also gives the grantor a final opportunity to remedy the default before enforcement actions commence. So it's sort of like the last olive branch before war begins. Consequences of non-compliance. So what happens with non-compliance in this case is that the secured creditor will not be able to pursue legal remedies, or they will not be able to do so until a proper notice is sent out in the fashion that it must be sent out in. If the grantor fails to comply with the notification in the format that we just went through, the secured creditor will be unable to escalate. So if they do go through all of the criteria that we previously discussed, what recourse is available? The secured creditor may sue the grantor for any payment due and owing under the agreement, appoint a receiver of the movable asset, lease the movable asset, take possession of the movable asset, or sell the movable asset, or pursue any of the other remedies under the Act. These provisions ensure creditors have a legal pathway to recover their funds while maintaining fairness in enforcement. So it's essentially a balancing in the rights of both parties. The Movable Property Security Act establishes a transparent regime for determining the priority of competing claims, and it's critical for minimizing disputes as it determines which creditor is paid first. In terms of general principles, perfected interests, which will be those registered in the Collateral registry, have priority over unperfected interests. Among perfected interests, priority is determined by the time of registration, possession, or control. Under the principle of subordination, a person may at any time subordinate the priority of its rights under the Act in favor of any existing or future competing claimant without the need for the beneficiary to be a party to the subordination. Subordination does not affect the rights of competing claims other than the rights of the person subordinating its priority and those of the beneficiary of the subordination. To elaborate in simpler terms, this principle allows a secured creditor or any rights holder to voluntarily lower the priority of their claim in favor of another creditor. And it's important to really unpack that the key tenet of this is there is no requirement for the beneficiary to agree to, meaning that the creditor can act unilaterally without the beneficiary being privy to that decision to subordinate in the first place. So why would a creditor agree to subordination? Well, subordination is often a part of a negotiation strategy where a creditor may choose to subordinate as part of debt restructuring, as part of a loan agreement, as part of a business relationship to foster strategic alliance, or possibly as an equity/debt type of investment. So under these kinds of arrangement, you may find this sort of subordination taking place. Fairness in disputes. So the Act also ensures that priority is maintained during insolvency or liquidation, protecting secured creditors' rights. A security right that is effective against third parties under this Act at the time of commencement of insolvency proceedings in respect of the grantor remains effective against third parties and retains the priority it had before the commencement of the insolvency proceedings, unless another claim has priority pursuant to national enactments governing insolvency and bankruptcy. So what this rule essentially does is it prevents unsecured creditors or lower priority claimants from jumping ahead of previously secured creditors. Without this protection, insolvency proceedings could lead to unfair outcomes where secure creditors are deprived of their expected recovery. And what this does is it encourages lending and investment activity, as it makes creditors more willing to extend loans if they're assured that their priority remains protected in the event of insolvency. Additionally, it protects and promotes business stability, meaning that companies can structure and restructure their financing with more knowledge, knowing that secured obligations will be respected in insolvency proceedings. So we're ready for the next poll question. If the grantor does not comply within the time period indicated in the notification to pay the money owing or perform and observe the agreement after the date of service of notification, the secured creditor may A. Sue the grantor for any payment due and owing under the agreement, call the registry and issue a complaint, or dispose of the security agreement. I think the questions got easier as we went down, so hopefully we get a lot of right answers.
Okay, I would like to encourage the audience to submit their votes. I'm not seeing the votes. And even if you get it wrong, we can talk about, the right answer and why it's correct. Okay. So we got 171 votes on that question, and 81%, the majority of the respondents selected A, 11% selected B, and 8% selected C.
Great, so happy to announce that if you selected A, you would have gotten it correct. So the majority of you definitely understand the material. So thank you all for coming out. It was a pleasure to have you all, even though my section was the shortest, and it was a great experience to be here with you all today. Take care.
Thank you, Alexander, Tira, Nicole, for that very insightful and informative presentation. Indeed, it's important for us to review critical components of the legislation because we need to understand what our legal rights are when it comes to this framework. And the legal rights of this legislation covers various persons. It covers individuals, it covers businesses, it covers creditors, it covers debtors, grantors. And as we go reading it and we go engaging with the registry, we get to understand more. So with that, I would now like to introduce our next presenter. Our next presentation will look at the secure transaction and collateral registry, the services available at the registry, how it works, what are the products, who are the users, how you can access information, how you can do searches. All of these things will be discussed next. This presentation will be delivered by the Deputy Registrar, Mr. Santiago Gonzalez, who is no stranger to many. Santiago serves as a Deputy Registrar at the Belize Companies and Corporate Affairs Registry, bringing over 20 years of experience in corporate registry services. His contributions have been instrumental in advancing and modernizing this sector. Over the years, Santiago and his team have dedicated efforts to transitioning the registry from a paper-based system to a modern digital system. Their work culminated in the launch of the award-winning online business registry system on November 28, 2022, transforming registry services throughout the country. This registry has since expanded to include non-governmental organizations and what we are discussing today, the Collateral Registry. Santiago, I now hand over the floor to you.
Hi, good morning, everyone. And thanks to Tira, Nicole, and Alexander. That was a great presentation. I believe they covered everything. So I will go ahead with really, like as Yuri said, the section with the registry. And overall, it is a digital database. And on our end, what we're seeing by doing this system is that it makes it easier and faster for the lenders to register loan agreements. We have been seeing it for the past two months. It's basically within 24 hours that we do that. In most cases, it's within the same day. So by doing this, it basically builds a trust between the lenders and the small businesses, and we're hoping that this will definitely assist them for them to get these loans on these movable assets. Who are the users? It would be the financial institutions like what have been mentioned before, the banks, the credit unions, and DFC. We also have the private institutions. There's a growing trend that sometimes employers would actually give loans to their employees. So basically, they would be able to upload that information there. They can be a user for this. And the attorneys, individuals, it would be something where maybe you and one of your friends, I would give an example of a car. You have a car and you're actually selling your friend the car, but he will pay in installments. It would be very good for you to actually register that. It's either you write an agreement or, again, the attorney can actually do it for you on your behalf. The government institutions, they could actually do searches on what is on the register. And again, the internal users, which is the BCCR registry staff that would actually process these documents. We're not there. I just like to explain the registry staff. We're not there to actually review the whole agreement. We go specific to, for example, serial number to make sure the serial number is correct, or anything to do with the name. So that's really our job. The financial institutions would upload. We go more to verify that they actually put in those the right information regarding the serial number or the vehicle type that they're getting the collateral for. How does it work? I think everyone in this, actually, you have access to OBRS, I would presume. It is something that we have a lot of users. So it is built within OBRS. And if you have a user account, you would actually be able to view this by now. For the financial institutions, it would be basically something that we would upload them. Individuals, again, if you don't have an account, you could actually open an account, log in, and just follow the simple processes on how to onboard yourself with OBRS. The types of service that we have, again, this has been covered, which is the registration of the security right. You can amend it or you can cancel. Information, we have the standard extract about the security. And we have also the short extract and detailed extract that we would say long afterwards. All agreements, meaning the agreements that have been filed with the Stamp Duty Act, it is something that you can also register. We are accepting it. It's free of cost. And actually it will benefit everyone, if these agreements are uploaded. And the reason behind that is that you could actually go in and search. So the more data we have in the system, the better for everyone. Even as an individual, like I said, if someone's selling you a vehicle and you punch in the serial number and you could see, okay, yeah, it has a mortgage to it or a loan to it attached to it. So this is where with the all agreements, we're actually, advising. We have seen the financial institutions are actually uploading this. So it is a good thing to do. The security right status, again, like companies or business names, they have a status, which is when it is registered. You could actually view. It is expired. They have done their legal obligations, canceled or archived. So it's many years. We just move it away from the system. What are the benefits? I think these are the main. It promotes transparency, reduction to conflict. In other words, again, you can't have a vehicle and you're selling it to someone else. Now you have the ability to search. The financial institution actually have the ability to search. So if anything like that happens, you have records of it. It's so much easier you can log in the system and you could actually view all these things. It would also.
Sorry, I think we lost Santiago.
Yeah, I'm sorry. I think internet connection, it dropped again. Yes, I'm sorry about that. And again, there's clear guidance on actions that can be taken should the lender there be a default. It increases the possibility for access to credit. I think this is the main thing, especially for the MSMEs. We have seen it with credit unions, where it's basically the SMEs that are the ones that are using this. In fact, they are the main ones that would have that. The fees are basically the small fees. For the individuals, as you can see, the registration is only $10. The short extract it's $15. That's just in case you want information on. Again, we always use vehicles. There's so many more, but the vehicle is our main ones. For the institutions, the price varies a bit, but again, it's very low, I would say, to register. The products of the registration. Now, this is what you would get in return once a registration, the security right is registered. But one thing I would like to make very clear, you heard about the timestamp. This timestamp is actually when the lending institution or the creditor, they have submitted and paid for the application. It is not when the registry processes it. That's a different time. So again, the faster you upload your documents and submit it, that's when the timestamp you would have. Okay. Then the amendment to security, it gives you all the information on the creditors, the grantors, the debtors, and actually the collateral, and again, the date that it was issued. The cancellation, we've had one so far, which is great again. We're moving forward. And this is the information, is the effective date, again, with the creditors, the grantors, and the debtor, and again, the date that it was actually issued and the cancellation. Products. The short extract is basically for the public users and the financial institution. And how you could actually request this information via the system is either you have the grantor's ID, you have the registration number, which is again on the registration that they receive, or the serial number of the collateral. This would give you basic information. It would actually tell you, yes, this vehicle with this serial number has the search criteria will bring up, and it has a loan with a financial institution. So then that makes you aware that, if you're going into an agreement with whatever the person, you are aware that they actually owe for that vehicle. So again, this is great for transparency on your end. And the detail extract gives you more information, but again, this is more for the financial institution and how they can get it with the grantor ID, registration number, and the serial number of the collateral. One of the reasons that we actually just have the detail extract and the short extract is that we don't want people just surfing in the system, typing in your name just to see if you have a loan in there. We want to discourage that. So basically, you would have to have the certain information so that you could actually view what is in the system. It's just human that they would be surfing. The information is there, but you need certain things to get that information. And where you can find out more, you can visit our website. we have our information there, the act. So we would advise you, just like with business names and company, to visit our website so you can get more information. And our social media, actually. Please follow us for more information with this. And that's it. Thank you very much.
Thank you very much, Santiago, for walking us through how the system works based on the legal framework that was presented earlier. I'm sure your presentation answered some questions that I see trending here. And I will leave this slide here while we delve into the Q&A, so that you can take note of the different communication channels that you can use to reach out to the registry. Should you have any additional questions as you go thinking about the webinar this morning. So now we are ahead of time, actually, which is good. We will now jump into the Q&A segment, speakers, and I will be directing questions to you. So the first question, and this is something we knew would come up when it comes to the exemptions, and I will direct this question to you, Nicole. Are you ready to take on a question? We lost Nicole. Okay. I will hold that question for her when we get her back, and I will move on to the next question. So the question, and I will direct this question to you, Santiago. I think this is something that you can best answer. We have in the past observed that while the registration of bill of sale was registered with company registry, I think that person probably meant the lands registry.
The land registry.
That bill of sale is registered at the lands registry. The traffic department or traffic or transport department did not have knowledge of the lien and would process a transfer to a third party nonetheless. And this is something actually that has come up in several of our training sessions and sensitization, Santiago. Can you kindly answer that question?
Well, on our end, once it's registered with us, the information would be there. Should in case the traffic department would like, we are hoping that in the future, and this is where these systems are good, that in the future maybe we have an API or a way to actually interconnect with the traffic department, because I think it is needed. Especially when we hear certain things that they would just get a copy of their vehicle ownership. But this is something that in the future we would actually like to see where we can actually connect with them to have better processes.
Right. But as it stands now, I mean, they can use a system to even do
Yes,
research,
yes,
correct?
they can. Yes, they can. Yes, they can. Exactly.
Exactly.
Yes.
So now the system provides the ability for such a department to conduct searches. Right.
And so it's way quicker also too. Yes.
This is a transparency part we're highlighting this morning. Right.
Yes.
Okay. Nicole, welcome back. You're in mute.
Thank you.
So I'm now addressing this next question to you. Section 4 contains two further exclusions: sea vessels and aircraft. These exemptions were left out in the presentation this morning. However, there is some confusion around it. So what are we planning to do, or why did we exclude that from the presentation this morning?
Okay, thank you very much for that, Yuri. So I'll start, and of course, I'll invite any other colleague who may want to add to it. The movable, this new framework, this new legislative framework, it is in fact new, and with any other legal framework, when you implement it, you would learn and see, what exactly is required given the environment we operate. Mm-hmm. Yes. For the person who posed that question, you are in fact very correct. There were two other areas included in the law. upon implementing the act and, upon the registry getting up and running, we have realized that there are a lot of there's a lot of interest, and a lot of persons are in fact looking to leverage vessels and so forth. And that was not originally anticipated in that way. So owing to that, we are reviewing the framework to see how best we can ensure that, one, we do not cause any conflict with any other existing regimes, but we also take into consideration the realities of Belize. So noting that, and noting I don't want to say the confusion, but noting that it has created some doubts, in persons' minds in terms of how exactly to apply it, we decided to exclude it here, and just also to further note that we are reviewing the legislative framework to see what we can carve out, so to speak, that would be best for the context of Belize. I'm not sure if Santi may want to add anything, or Tira, or any other colleagues.
Thanks. So I, of course, endorse whatever Nicole has said, and also to note that the issue is we have to make sure that there is no conflict. But this is also a new regime, as persons have brought up things, maybe in terms of certain vessels, there is actually no regime, even though it may be in another law, there may be no regime that actually deals with, say, small fishing vessels or small vessels that is used for artisanal purposes. So if that is the case, then we have to make sure, we need to, if we need to put in regulations, or if we need to just have a discussion, the BCCAR just has to have a discussion with any relevant agency under whose mandate another law comes to clarify the issues. So as we said, it's new. It's new not just to Belize, it's also new to the Caribbean. So there are certain things that have to be decided and ironed out as the implementation of the law progresses.
Thank you for that, Nicole and Tierra. So indeed, it is something that the registry is currently reviewing, since there is interest, and indeed since there is some confusion or lack of clarity when it comes to addressing those two items. Okay. I will now address this question to you, Santiago. Again, on the bill of sale, how does this new act affect the creation of security interests under the Bill of Sale Act and the registry established under the Bill of Sale Act?
How does it? I'm trying to picture what exactly is.
I guess the differences between the registry under the Bill of Sale Act and this registry, and how they relate and how they don't relate.
I think that was kind of explained by the attorneys, and in our point of view. Again, the main thing with this act is that we actually you could have it in the system to actually register. I think there were certain things in the Bill of Sale Act. It's just like we're saying with the airplanes and that are not allowed with us. So I think that's more of what we are seeing then.
Right. So in other words, all the immovable collateral, such as land, such as building, when it comes to securing loans using those type of collateral, that is still under the purview of the Bill of Sale Act.
Bill of Sale Act, unless if they are a company, then they still registered under the Companies Act. So yes, that would be the main. You're right, Sheree. That would be the main difference there.
Right, and then movable assets then come over to this registry.
Yes.
Okay. Next question, and anyone can take this, or maybe you should take it because it's really more a local context type of question, Santiago. Will there be a history or default or a credit score kept for grantors?
That might be something in the future, but not now. Again, we're starting with, we're just starting with something, and I think that's a very valid question, because then we're gathering data. So that would be definitely something that we would have to think in the future. What can we do with this data, and how can we move forward with that? So that's definitely something that I truly believe we would have to think for in the future.
Indeed, indeed. Excellent question and point there. And as you mentioned, Deputy Registrar, this registry and this regime really starts setting the foundation for such possibilities to come about for the country. Again, I think another question for you, Santiago, but others can also answer. How is this relevant? So this meaning the whole regime and what we're talking about this morning. How is this relevant to the general Belizean public and their relation with registered agents and the platform? Is anyone able to create the security right, or will they be included in assisting drafting, filing said security right?
With a drafting of the security rights, again, it's not up to the registry. So far, we have seen it's basically the financial institution. So that has nothing really on our part. But definitely we're seeing, as the system that's being used, and we're gathering more information, more data. And I think everyone has a better understanding of using it. We are definitely hoping that the financial institutions are really giving loans to the small MSMEs. There's a trust between what we have now. So that on my end, I think that would definitely be a benefit.
Thank you for that.
On my side, just as an observation, I'd say in relation to the general Belizean public, they now have this opportunity to access credit or manage a sort of parallel credit system where they didn't really have that option before. So it really opens up a lot of avenues for small businesses to get from 0 to 1 and actually get to the point of having audited financial statements to access the main financial system. So it does a lot in bridging the gap in that regard. And also the simplified registration process does a lot for ease of doing business within the country, as it helps you to really formalize what you have on the books versus having to go to an accountant and having a valuation for things being done. It's now a lot easier to legitimize those assets. And in relation to the role of registered agents, I would say even though their role might be minimized a little bit, they're still going to be needed for let's say international transactions and also complex transactions. So where you have a need for the legalese to be deciphered, or where you need a thorough representation on behalf of a foreign body, they'll still need to be involved. So that's just my 2 cents.
Right. Thank you for that, Alexander. There is a question here. I'm not quite following it, but I will read it out nonetheless. And I think this question was raised during either your segment, Nicole, or your segment, Tara. Ownership of vehicle have an or. So I think it's the and or that's in question. How does this play out? Would you require both or either one?
I'm sorry, Yuri, can you kindly repeat the question?
Yeah, well, it's not a full question. I'm trying to dissect it here. I think in one of your presentations, you had ownership of vehicle, have an or. How does this play out? Would you require both or either one? I mean, I guess they're trying to say if you need more than one movable collateral or just one. Or trying to figure it out here, if you are the owner of the asset or you're not. Maybe it's more to that angle.
You see, I don't want to respond
That's okay.
correctly because I'm not 100% sure what the question
So that
is.
if that person can provide clarity on that question, and we will move on. Okay, next question. All right, so another question here about the transport department, and I believe we had already answered that question, that the registry is here for the traffic department or the transport department to use to do searches if they wish to before they make a decision when it comes to transfer of titles. Yeah.
If you
Next
don't mind,
question.
Yuri, I now understand what the person is asking. Because
Sure.
the title is and or do both need to sign? That is the question. Usually in and or only one needs to sign. Usually, yes. But it will
Excellent.
all depend on the the actual context of the agreements and ownerships and any other laws relating to it.
Excellent. Thank you for that, Tira.
Yeah, sorry for disturbing.
This question, I will leave it up to any of the presenters to answer. Can a pledge of shares in a company where a shareholder uses his shares in a company as collateral be registered? So in other words, can someone uses his shares in a company as movable collateral to access a loan?
I don't mind giving that one a try. So I'd say prima facie, no, because you consider shares in two categories, public and private. On the public side, it's going to be governed by the SEC Act. On the private side, it's going to be governed by the Companies Registry Act. So the transfer of which and the parameters under which you can transfer them are all contained in that act. So at first blush, I would say no. But I entertain other views by my fellow panelists.
Any further comments on that one, Nicole, Tira, Santiago? No? Thank you.
As Alex says at first blush, I would also agree with him. This is something that if there is some precedent for this happening, something that as the law evolves, as the practice evolves, we can take a look at, but I don't see it being considered movable.
For now, no. Excellent. Thank you. Okay, next question, and I believe this was answered already during Santiago's presentation, but I will ask it still. Will the registry be open access to the general public, or will access be allowed through process that protects individual entities' privacy? So I believe this is something that you had explained, right, Santiago, in your presentation and how this works?
Yes, would actually, I had explained, I think you could actually just search by, for example, the short extract by if you have certain information. It's not like people can go in there and just surf and be looking for specific things. So that would be the answer that no, it's not to say it's open in a way that no one can use it, but not open that you can go and do search for whatever it is that you want to see. That would be the.
Thank you for that, Santiago.
And I was going to add to that, that is the best practices now for registries. Before, when you had a manual registry, persons were able to go because, of course, it wasn't computerized, so you had no choice but to give them the books and they would go and look through it. Of course, now, in terms of electronic registry, you can't give those rights because you have data privacy issues. You just can't have somebody basically accessing the entire registry, the data of everyone's names, their addresses, very personal data. So that is in keeping with the modern best practices for companies and other registries.
Mm-hmm. Thank you for that, Tara. Indeed. It's always good to know what the international best practices is also saying to ensure that we are aligning to that. If not, we can get in trouble as well. So it's good to know. Does the scope of this act include collaterals already registered and created prior to this act, or only for securities created since the effective date of the act? And I believe this is something you've also explained in your presentation, Santiago, when you explained the possibility of individuals or institutions being able to register agreements already perfected before this movable regime was enacted. But I will still hand over to you.
Yes, and in actuality, it's free of cost. So you can register the pass. There's no fee attached to it. Again, doing it because the more data we have, the better the system. And it would work to the advantage of all the financial institution and the public with
Yes.
that. So that would be it.
Thank you for that. And just for clarity, when you say free of cost, it's free of cost for the existing ones.
For the yes, for the existing.
Not for the new.
That's what you.
All right. Now this one is directed to you, Tira. The asset remains in possession of the debtor. Does Act speak to a proxy third party, warehousing, or storage? So I think they're thinking physical possession. So can you explain what possession means, and also maybe the role of the debtor, the grantor, again, for clarity there? You are on mute.
Yeah. Sorry, can you read it again? The question?
So the question reads, the asset remains in possession of the debtor. Does the act speak to a proxy third party, warehousing, or storage? I was saying that I think the person is thinking physical possession. So if we can go over what possession means, and also the role of the debtor and the grantor for clarity as well.
Okay, thank you. So the pledging something as collateral does not mean that you take it and you put it away somewhere. So for instance, you are a farmer and you have farming implements, or you have cattle. You are then pledging this, but at the same time, you have your collateral for use. It is just basically a security. It's the same way when you mortgage your house, you're still living in your house. It's just that the house provides the security. So there's no reason that anything has to be warehoused or kept somewhere because it's pledged as a collateral. I hope that answers the question.
And just to draw a parallel that everybody understands, your bank generally has possession of your house until you pay off your mortgage.
Yes.
Right.
Legal possession. But you are physically in possession.
I was just about to say, because they don't warehouse it anywhere.
Right. I know in one of the sessions that we had with the institutions, what one credit union, for further clarity as well, what one of the credit unions explained to us is, they use cattle as part of the collateral to secure a loan with a farmer. But it's, farmers are constantly selling cattle, they're doing something with cattle. So you cannot secure specific cattle. So it's a specific number of cattle within the herd. So that is how that works. So all of them kind of work in different ways, but it's not physical possession of things. Thank you for that.
And if I can just add before you close off on that, in terms of the reference to cattle, of course, for the farmers, they would utilize the cattle as, some form of generating their revenue as well. So taking the asset from the possession of the small business as well can affect their ability to honor their obligation. So that is something as well we have to bear in mind practically. Also.
Absolutely. Thank you for that, Nicole. Will the Bill of Sale Act remain? That's the question. Or will a new format be given by BCCR under the new regime? I think so. What the person is alluding to is the way the agreement is written. And we explained about what will stay with bill of sale earlier in terms of all the movables and movables coming over to this registry. So can you explain a little bit about that, Santiago?
Again, I would also, I would just reiterate, we have just started. We never know how we will improve. But for now, again, we are just doing the movable.
Yes.
I
And
would
immovable
happen,
was right.
yes, yes, immovable with the bill of sale. But what might come out in the future, we don't know. But it is an idea once, everything is possible.
Right. So all immovable things remain with bill of sale, the lands registry, and they have their own format. And all movable now come over to this new registry, and the institutions need to create their format citing the movable property security rights.
Yes. Yes.
Next question. If a grantor assigns a security as collateral to be utilized in case of default on an account, and the creditor does not apply said collateral upon default, how does this act help the grantor, and how can the grantor enforce this assignment? The floor is open to answer that one. I can read it again. If a grantor assigns a security as collateral to be utilized in case of default on an account, and the creditor does not apply said collateral upon default, how does this act help the grantor, and how can the grantor enforce this assignment? So I think it boils down to your loan agreement terms with your individual lender and financial institution, correct? Can someone further elaborate on that one? Anyone? Nicole, Santiago, Tira?
I think most of us we don't fully understand. I think, well, for me, I'm trying to look for the actual question to see if I can read it
Right.
to have a better.
Are they trying to say that the creditor is refusing to take the collateral, that the person is in default and the creditor is refusing to take the collateral? I think that's what they're trying to say.
Is that what they're saying?
I don't know.
I'm not sure. Because my interpretation of it is a bit different in that, they've reached, they've already entered into some kind of loan agreement with the creditor, but then the grantor wants to assign some next collateral as default. I mean, really, when it comes to accessing credit, it's an individual discussion borrowers have with whoever their lender is, or whoever, whether it's a financial institution or individual. And the terms are very clear in that agreement, and the terms are clear when it comes to default as well. So it is really guided by that loan agreement. Am I correct in saying that? I think the person is also inquiring, how does this regime help in the event of a default? Or what is it saying in the event of a default?
Well, there are provisions in respect of post-default procedures. Those are clearly outlined in the Act. In fact, I believe Alex touched on it in his presentation, and even one of our poll questions actually spoke to it. So there are clear provisions in the Act in that regard.
Thank you for that. And of course, if that person needs any further clarity, feel free to reach out to us, and we are more than happy to provide any additional information. Okay. Next question. Regarding properties that are obtained through statutory declarations, will the FSC keep the statutory declaration impeding any sale if it is tied as a collateral securing a loan facility? Open floor.
Can you repeat again, please? Sorry.
That's okay. Regarding properties that are obtained through statutory declarations, will the FSC keep this statutory declaration impeding any sale if it is tied as a collateral securing a loan facility? I'm not sure if it's 100% clear, but
Santi, what are the properties acquired through statutory declaration?
And that's exactly what I'm thinking about, because really we're not speaking about property.
no.
So
That is with bill of sale.
So our focus, this law in particular, focuses on movable.
Correct.
yeah, unless we are thinking about bona vacancia, but that would not be nothing to do with this. So that would be something totally different.
Correct. Now, question regarding the title of the legislation, and I think maybe we can provide clarity in terms of what is it that we're trying to achieve with this legislation. So the question goes, why wasn't it called MPL, Movable Property Lending? I think that wording is more self-descriptive and would provide more mileage among the populace. So why do we go with movable property security rights? What is it that we're trying to do?
Well, to me, it's the rights and the substantiation of those rights that grounds the lending. So the act itself needs to be, the focal point of the act needs to be the substantiation and protection of the rights, which then crosses the pathway to allow you to lend or do whatever you like with your assets. So to me, it would tell a piece of the story, but not the whole story.
Thank you for that, Alexander. Indeed, at the end of the day, the core of the register and the core of the legal framework is to register and perfect security rights when it comes to using movable collateral. The lending part, all of that happens with the financial institutions or the lenders, the terms, the valuation, all of these things happen with the lender itself. The registry is here simply to provide an avenue and the legal means to register the security rights, thereby creating that legal certainty for the lender and transparency for the borrower, etc. So just to emphasize what you just raised there, Alexander. Thank you. Right. So there is a recommendation, not a question, that we should consider putting in legislation to emphasize that GOB entities such as the traffic department attach movable property security certificate or encumbrances, etc. Before, I guess, they decide upon a transfer. What is your comment on that, Santiago, or anyone that would like to comment on that?
I think with that, I see with what we're seeing right now, again, other institutions are adapting to the system. It's new. It is something that, again, maybe the traffic department, I can't speak for them, would be something with their procedure that actually whenever they're doing anything, they could actually search the system to see if that vehicle, has a loan registered. But then again, or maybe we could actually think about something that we could provide to them so that, they are aware of this. But it's something, again, that we would have to think about.
Thank you for that. Next question. How does the Act prioritize security rights when multiple creditors have claims on the same movable asset? Example, If cows are used for collateral to two different creditors and the client defaults, who has the rights to claim on the movable asset? Really good question there. Again, open floor.
I think in our end, we would say that it would be the one that registers first, and that's why the timestamp is, you actually, that's the main point of this, to register it, you get that timestamp, if I'm not wrong. So they would actually have the first preference. They're the one that registered first.
Thank you for that, Santiago. Any other comments regarding priority of security rights and claims, Tiara, Nicole, Alexander, Claire? And I will be doing two more questions before we conclude our session this morning. This question is for you, Santiago. Is there a deadline for registering existing bills of sale, specifically those that were created prior to the enactment of this act?
So far, there's no deadline, but maybe in the future, we would actually put a fee to it. But for now, again, it is free, but it could change that if you want to register, then we will charge a small fee.
Yes. Yes. I mean, and just to highlight that the registry has been live not even 2 months. So and it's already
yes.
already has so much interest, and this is why we're having this discussion, to raise awareness, and we're going to be doing more. Rest assured, we're going to be doing more publishing of content and explanation of this. It is very important for Belize. And then last question. In relation to the registration process, can one asset be used to secure several facilities? Example, further explanation, splitting the value of the asset for different loan agreement. Open floor.
Well, theoretically, yes. I have seen it done already, but usually that's done like in perhaps one, an agreement where you actually have two creditors and one grantor. I've also seen agreements where it's just like, say, a second mortgage then. So when the first collateral, the value that was given is much under, say, half the value of the collateral, and somebody else takes a further value. That's theoretical. But I've actually seen in other countries, other places, where you have two creditors for one collateral. Again, to that collateral has to have the value, where maybe to each person say something for $1,000, and each person say, okay, I will lend 500, and the total value exceeds 1,000.
You mean the total value can't exceed 1,000?
Can exceed it. It would be at least 1,000, because
you mean the value of the assets? Okay, yes.
Of the assets, yes. Mm-hmm. But I mean, as I said, I've seen that already. It may not necessarily be a wise thing for persons to do in terms of trying to get back their money. Yeah,
a creditor may not even want to do that.
Right, but sometimes people do it. But well, I mostly see it in terms of like their person's family. I mean, this is reality. A lot of times, people are getting loans from their family, and right now it's more like just on honor, based on honor, or based on promise. And we know how sometimes that leads to a lot of disputes and family breakups and so on. This way, you want to get a loan from your family, where you say, well, okay, I pledged this, and you do it in a proper way. So I've seen it already where somebody, say, two family members say, okay, I can give you 500 each, and you pledge it. So I don't like, this is not something often that's done like for movable property at a bank or financial institution level, but maybe persons, relatives, friends.
Great. Thank you for that, Tiran. Interesting indeed. So we have now reached at the end of our webinar. Time does fly. when you're discussing interesting things. I want to thank all the speakers for taking the time and for presenting on various components when it comes to the movable property security rights regime. I also want to thank the audience for tuning in, for participating, for asking all those great questions. We will be compiling all of them and we will be publishing the answers on the website. You will also be getting an email from us directing you in where to find the FAQs and also directing you in where to find a copy of the different various presentations and the recording of this webinar. And of course, just to let everyone know that we are still on the path of rolling out our communication campaign when it comes to raising awareness of this very important regime. This regime is important for businesses, individuals, creditors, lenders, employees, employers. So it's good for all of you to understand what it means. It doesn't necessarily mean that all of you will be registering in the registry, but it's good for you to understand how you can tap into opportunities for your individual needs. So with that, I say thank you and enjoy the rest of your day.